We are the lead plaintiff in the SHSAT, that's the Specialized High School Aptitude Test discovery lawsuit. The Christa McAuliffe Intermediate School PTO as the lead plaintiff in the lawsuit against the DOE and the city of New York. And this stems from a policy that was put into place about 2 years ago when the city expanded the discovery program first to 12% in 2018 and then to 20% last year. So what is the discovery program? Well, as most of our community is aware, there are 8 high schools, including Stuyvesant, Brooklyn Tech, Bronx Science, and Staten Island Tech, that require applicants to take a single exam called the SHSAT. Over 30,000 students take this exam for roughly 5,000 spots. Unfortunately, very few Black and Hispanic kids make that cutoff. And instead of doing the common sense thing, like building more schools to satisfy a demand that is clearly there, the DOE decided to try to expand the discovery program. The discovery program was around since the inception of the law, Heck Calandra, that mandated that a single test be given to populate these schools. Kids who just missed the cutoff were recommended by their principal and who had successfully attended a summer school program were able to matriculate at these schools. Well, in 2018, the DOE expanded the program. They threw some other stuff in there, okay, that we felt was very problematic. What the DOE said was that not only did a child have to satisfy all the other conditions, the cutoff, the principal, summer school, they had to have an ENI, Economic Needs Index, of 60%. Well, I mean, that sounds reasonable. Okay, so we want to get kids who are poorer, fine. But additionally, they mandated that the middle school itself also have an ENI of 60%. And that's where the problem, stemmed from. Well, prior to 2018, Christa had sent more than 1/3 of their kids to these schools. Okay, now that was a point of contention to some individuals in the DOE and in politics who accused us of, I don't know what, of being too successful, being too good. I don't know what their issue was. But it became problematic even further when the chancellor and others made a series of public statements about, and this is in sum and substance, too many Asian kids, okay? That became germane because when you look at the schools that do not have an ENI of 60% or greater, many of them are majority Asian and send kids to the specialized high schools. In fact, Christa is 67% Asian and has an ENI of, wait for it, 58%, and 60% is the cutoff. Coincidence? I don't think so, okay? So this happens in June of 2018. Shortly thereafter, I was introduced to the people of Pacific Legal Foundation. They themselves are a nonprofit legal group that picks up cases on a pro bono basis. They felt, and I agreed, that the city's intention was to increase the number of Black and brown kids by intentionally reducing the number of Asian kids. Intentional discrimination against Asian children. Now, even if the reason they are doing this is well-intentioned, which is to increase the participation of Black and brown kids, it is unconstitutional to discriminate against some people to help others based on race. Okay, that's the essence of our case, and the case itself is ongoing. COVID has slowed everything down. It was filed in federal court, and PLF says that if they feel that it's appropriate, they will argue this case all the way to the Supreme Court, where I might add, PLF has a impressive number of wins. They've been to the Supreme Court, they've done well there, and we would hope that they would do well with our case if it doesn't get settled before that. So I gave this spiel last year. Some of the incoming parents, they had no idea that this was going on. They had no idea that we were plaintiffs in this lawsuit, that the PTO was a lead plaintiff, that in essence, if the PTO is a lead plaintiff and they are members of the PTO, that they were involved in this. And they were horrified. They many of them, or a couple of them, were against screens, against testing, against the SHSAT, specialized high schools. They thought that it was a horrible system, and they were upset that they were now parting. One parent wrote to Mr. Berman an email accusing me of being a racist, or at the very least using racist rhetoric. If you are out there and you're one of those parents that feels that way, I respect your opinion. I really do. But everyone needs to know that PTAs and president's councils and CECs are all independent organizations with elected bodies, right? Executive officers elected by their members, you guys out there. Okay, neither the principal, the superintendent, the chancellor, the mayor, the governor can interfere unless, of course, there's some illegality, right, or impropriety. And most of that times that involves theft, like misappropriation of funds, commingling of funds, stuff like that. I mean, not this. Okay, this is not something that any of those individuals can stick their nose in. Okay, that's just not appropriate. You know, Mr. Berman loves emails. If you want to email him and complain, do so, but it's not going to in any way affect this lawsuit, or Mr. Berman can't kick me out or do anything like that, okay? Only you can kick me out. How did we get into this, right? I mean, Vito didn't take it upon himself to sign up with PLF on my own, right, on his own. I didn't do that, okay? So PLF came and we had an executive board meeting, and the executive board voted to present it to the members who voted to proceed. So it was only after we had two separate elections that we could sign on with PLF. And in fact, at the time, we also voted that the only way to withdraw from this lawsuit would be for some future executive board to vote to present it to the members. That's you out there. That's all of you out there. Again, all of you. And the members would have to decide by majority vote to withdraw.